You are Yolanda Martin.
Yes, sir.
John West is here representing you. And this is a theft case, state jail felony of theft. And why we're here, you know, you tested positive for cocaine on a drug patch that was collected on January 17th. And it was analyzed, and that violates your terms of bond. You shall not stand by. I see another one.
Yes.
That was collected back in October. That was positive as well for cocaine. Then there was another one. That was, I'm sorry, October 12th, October 25th, collected positive for cocaine. And then we have another one, this most recent one here, January 17th, collected, and it tests positive a third time.
That's probably
Okay. Can you explain?
Your Honor, she had, I'll let her speak a little bit too, but she's talked to me quite a bit. I think that was the first a drug patch issue. You revoked the bond and she would make bond again and got out back again. She has gone to recovery, to rehab. She's cleaned up. She has been adamant that she has not been using since that first drug patch issue back then, that she stayed clean. She's made every effort to stay clean. We are unsure why it's tested positive.
Maybe it's because she has cocaine in her system.
It maybe not cleared out, but it should have cleared out by now. I don't know. We would, if there's any chance, Your Honor, the court would be willing to test her and do an on-the-spot test.
What difference would it make?
Well,
What was it? She's failed the tests.
but it was
Another test, she can't purge past tests.
Well, if she's dirty today, then we would have any argument, and then we just have to deal with it. But she's adamant that she's clean, and she has no idea what is causing this to come up dirty.
You're relying on her word, and I'm just looking at the indictment with her 16 prior theft convictions. Her word's not worth much unless it's validated and supported by some corroborating material. 16 convictions, and she's charged with a theft, and that's why we are here. A felony, when you steal a pack of gum, it's a felony because of your rich history of theft convictions. But thefts are used in evidence to show character issues like dishonesty. And your word is not good enough. I'm going to rely on science, on the drug patch. What else?
Is she speaking out? But
I have not used it since.
Your word.
I
That's
understand
what
what you're saying, but I haven't used since March the 16th of 2023. That's the last time I used. I've been doing everything I'm supposed to do. The people at the patch company said if somebody touched me or anything, it might get on my system. I do ride the city bus. I have gotten a job. I work every day. I go to work at 8 o'clock in the morning. Every day I have got a job, and I've been doing everything. I don't even go nowhere. I stay at home. Only thing I do is catch the city bus, maybe touching somebody's doorknob or shaking somebody's hand. But other than that, I have not put a drug in my system.
Oh, please.
I'm sorry, your word's just not good enough. When you have a rich conviction history of thefts, which are used in the rules of evidence.
It was all a lie. Guys, it was all a lie. She lied.
As evidence for character and truthfulness. Sorry, I have to rely on something like the science. And this is the third positive while on bond. And I'm either going to rely on this or not. Your word, I'm sorry, your word is not worthy. You have proven this since 1992. What is her bond?
I believe it's
What is it now?
It's 40,000 now.
It's doubled to $80,000. And she will continue to have a drug patch as a condition of bond. That is all. You're taken into custody. Thank you, ma'am. What do you want to do for the next event, John?
Your Honor, I'm gonna talk to Dan, see if we can possibly work it out. Today, if we can work out something. So, we were originally gonna set it for trial. That was the point. So if I could put down with this, we may change our position.
Motion, a written motion, this bond, or is this just brought up oral? Because that, I look for one and I cannot.
Here's a copy of one,
But like one for this particular one, not a previous. Here, but that's what we're going.
the second motion is what we're
This was filed
in August of 23.
23.
Yes, sir.
This is, we're going on the August 23 motion.
Yes.
And this is a follow-up from what?
That's my question.
No, it's a follow-up from,
What ruling was made then,
yeah.
that we're continuing.
At the time that this motion was made,
What
there have been
motion?
records that hadn't been produced to us, which is still the case with regard to the medical. And I believe the statement from the court at that time was somebody could walk over and get those today. This is when you were first coming onto this case and Sonny was discussing it, and we discussed the facts.
I came on in October, 2 months before I was there.
So, and at that time,
You're asking for relief on bond, right?
yeah, sure.
All right. I don't even have any, I don't know when the matters occurred. I don't have any writing on the outside, which which bothers this court. I don't know when these decisions were made. There was a second motion in August 21st of 23 that was filed. And I guess that's what you're talking about.
Yes.
And you want to, but we had a hearing on that and I made rulings on it, correct?
No, Your Honor, we've never had a full hearing on it.
Have we had a hearing? When was the last time we had a hearing on this? Does your records show?
The last time there was a decision made on a bond,
We're talking about a hearing on the matter, whether or not a decision was made. When was the last time we had a hearing? Thank you.
my records don't indicate.
Mine don't either.
The state file doesn't indicate that
This,
there was anything. The only thing the state file indicates is the 2022, December 22.
I mean, I'm prepared to proceed with it as though this.
are you ready?
We can go forward.
Are you ready or not?
I'm ready. Whatever it is. I just want to make sure what we're doing. That's my,
Well,
I look forward to try to decipher where we were. Like if we're reopening a hearing that's already started, if this is just a continuous bond thing we're going to do off one motion that's filed 3 years ago, that's my question, Judge. Where are we procedurally with this?
the question really I have is what prompted this hearing for today? For this matter to be placed on today? I'm really not sure. Because I don't see anything that prompts it.
It was a discussion at a previous trial setting, Judge, and the court said, well, that the court would be willing to consider some circumstances surrounding the outcry to set a hearing on it. And so that's what we.
Okay. Are you ready for
Judge,
that?
I want to be clear though, first of all, what prompted this hearing is that I believe it was 2 weeks ago, we were set on this vote where counsel wasn't available for medical reasons.
Correct.
But state was here for it and the witnesses, obviously, the family was here. And then it got reset. So I want to remind us of that. I don't know what that was. We were ready then, we're ready now. But I just want to make sure it's clear.
Well, I mean, if you need to respond, do you have witnesses available today to respond?
There's not a, I mean, Judge, I don't know that's my point of this. I'm not sure what we're here to do other than discuss 1715.
What do you intend to do?
I intend to put on the mother of the victim to discuss, the fact that there was an external hymen present, that the loss of Virginia coincided with an entry in her journal. I further intend to argue the fact that the state still has to produce the records from Spindletop, and is also saying that the announcement when it was numbered was not ready, and then you said, but you're ready aside from wanting the other case to go first. That's, even if the court doesn't reduce the bond today, we need to address that issue, because it would be manifestly unjust for my client to remain in jail while a case that is newer with the same complaining witness was tried to the court. So I believe that my client is entitled to a bond based on the fact that the remaining medical records have not been presented to us as they were supposed to have been some time ago.
What about that?
Judge, it's the first I've heard of a discovery issue.
Here's what we're gonna
This is what this is.
No, here's
It
what
can
we're
be
gonna do. I'm gonna ask you to do this, Mr. Wilkerson. Because I don't like the way it's been impromptu addressed orally, and the state's bewildered. Put this in writing so it can be. Is this bothersome for you? Put this in, articulate your needs as soon as possible. Put them in writing so we can memorialize it, so everybody can be on notice on what the hearing is. I don't know what this is either. It's just an open kind of a thing. And I know it is prompted by the Court of Appeals decision on him that was just released. So, yeah, great, let's get this. I'll be having hearings every morning before we go into the trial in the next 3 weeks. And we can put that in there. I want to see in writing what you're talking about, because I'm not following you at all. And he gets a fair notice of what is needed. Do you understand? Can you do that and get that as soon as possible? You get it, file it, I will set it within a few days. Do you understand?
Your Honor, number 6 and number 8 from the second motion address specifically what I intend to address today. Number 6 and 8 from the second motion was filed back in August.
Okay. What, are you ready for that?
Judge, I'm not, because I don't. That's our
When can
first
you be
question.
ready?
Whenever, we will get it as quickly as we can. 2 weeks.
What is that?
2 weeks. Give us 2 weeks so I can
You got a week.
keep them. A week's fine. I'll figure what out.
They're not ready.
We're not ready to decide what we're doing.
And truly, you're telling me right now at 9:45 what the particulars are that you want to deal with in this hearing. You got to tip us off a little better than that, especially in light, they got a different prosecutor here.
Yes, Your Honor, and respectfully, it was the first time that this motion was discussed. The transition was taking place. Sonny was here. It was when Mr. Hoppower was first coming into the case, and it was it was in consideration of the second motion, and the court said set a hearing on it. So ultimately, that is what we did, and be absent for medical reasons. The state was ready to proceed based on this motion, but today the state's not ready to proceed based on this motion. So I feel like the motion clearly articulates what I'm here to present.
If I can respond to it.
Yeah.
Let me be clear. The state was ready, to ask the questions I'm asking today. What exactly are we?
You'll need to, here's what I would suggest. Since I've practiced law a lot longer than both of you,
Yes.
I've never been in a situation where people are not communicating with each other and filling in the blanks. Either side is not clairvoyant. Y'all got to give each other, in all professional courtesies, a heads up of what the plan is. Not, it's going to be a bond deal. Okay, I say, okay, fine, but that's a global statement.
I hate being kept in the dark.
It's not fair to either side what the parameters, or we could be here for months, years. And I don't like that in light of this, my trial docket, my overall docket, and often lately, that's what's happening. People are coming in and surprising each other.
What we've got here is failure to communicate.
I never grew up with that in the practice of law. It was always people knew heads up what the plan was. They talked to each other about, this is what we're going to be doing. What do you have for me, so that we don't waste everybody's time when we get here like we're doing. And there's not the professional congeniality that I'm used to. Y'all need to communicate. You're in the business of communicating. And I don't like hearing, I'm not sure what this is. I don't know what it is either. And I don't find that you are communicating with each other so that we can come up here and save time, so that the hearing on the merits can be held, and not antics like I'm performing on why is someone up here surprised. And there should be no surprises up here. There should be nothing about ambush of information. Get it done. You got 1 week. All right. And get this man's constitutional rights dealt with, but inform each other. This is not just an open door to go, we're going to do a bond hearing. There is no limit to that. What do you have to say?
Respectfully, Your Honor, again, this particular motion was brought up to the court when Mr. Power was first taking over this case.
Are you denying that?
I did not just.
This is not what I like to hear between professionals. Work this thing out. You got 1 week. And get this man back up here on Wednesday. Can we do it on Wednesday?
Yes, sir.
Wednesday morning. Y'all be ready.
Yes.
So we can move through this. Does everybody understand?
Yes.
Sorry for the delay, sir.
Thank you.
All right. Don't communicate. You're in the business of communicating. Thank you. Okay. It's only constitutional rights at issue. This is important. All right. Who's up?
Your Honor, can we bring Mr. Chesno back out? I think we have something. To him, just get something.
What are we doing now?
We're going to go and plead true to the NCRP and just handle that one.
Tom, what do you have to do? Let's get you.
Why
This
not?
is really
I never got any of that notice, ma'am. That was after my sentencing. I didn't ever get any of that
This is
notice.
sick.
No notices about any of that
This
stuff.
is sick.